Good afternoon, everybody.
निकल गया। Please come. थोड़ा साइड कर दो, प्लीज साइड कर दो। No, from this side, yeah. Please be seated.
Good afternoon. I would like to call upon the President, Mr. Tewari, to come over the stage and give a welcome remark.
Sri Kiren Rijiju, Honorable Union Minister for Law and Justice, Honorable Mr. Justice S.K. Kaul, Judge, Honorable Supreme Court of India, Honorable Mr. Justice Nani Tagia, Judge, Honorable Guwahati High Court, Honorable Mrs. Justice Susmita Fukan Count, Honorable Mr. Justice Ajay Tewari, retired, and founder of Tewari and Associates, dignitaries on the dais and off the dais, learned members of the bar, representatives from student organizations and other participants and media friends. I am grateful to the Tewari Associates for supporting this event and for giving me the opportunity to deliver the welcome address come opening remarks to this lecture series on to explore the connection between alternate dispute redressal and local tribal modes of dispute adjudication. I consider this a privilege and honor. I am happy to see that among those participating in this lecture series are distinguished personalities of my state and others. I, on my behalf and on behalf of the people of this beautiful state of Arunachal Pradesh, extend a warm welcome to one and all present today. The theme for the lecture series speaks for itself, therefore it is imperative for me to begin by throwing some lights on alternate dispute resolution, the traditional way prevalent in Arunachal Pradesh. Arunachal Pradesh shelters over 25 major tribes and over 100 sub-tribes in terms of the populations. These tribes have their own traditional village councils and were in existence since time immemorial. Some of the prominent village councils are Nyel of Nisi, Buliang of Apatanis, Keva of Galos, Kevang of Adis, Shorgan of Mompas, Shoshung Council of Miji, also known by the names of Sajurong and etc. In the absence of express written records and of historical accounts, it is not possible to specify its exact date of origin, but it has been reported that when the concept of settled village and agriculture developed, The indigenous village councils took birth naturally. The wise and able elder of the village naturally commanded respect and became an authoritative figure of the village due to his wisdom, justice, and undisputed power he wielded. The society mainly practiced oral dispensation of justice with strong learning on supernatural and tribal ethos of natural justice and application of recognized customs and practices within the community. Prior to the enactment of this pre-constitutional law, the Assam Frontier Administration of Justice Regulations 1945 by the Britishers and Arunachal Pradesh Civil Courts Act 2021, all communities in Arunachal Pradesh used to govern per se regulated themselves in resolving criminal, civil and other disputes through customary law, a long-held practice, usage or belief which is immemorial and passed down through intergenerational in nature, in oral form within a community, custom being an integral part of cultural identity and ethnicity, governs the social life of a given community while in varied ways, and as a result, customary laws develop as a set of rules considered binding by the members of the society due to fear of punishment or social condemnations, where acceptance is a norm and disobedience a rarity. These unique traditional village councils managed to hold its sway at the village even during the post-independent era because its continuance is imminent for the existence and welfare of those people. Nevertheless, these institutions are under threat and dilution of its originality due to modern laws and civilizations. Hence, it is my considered opinion that efforts should be made by all stakeholders to preserve it, as these tribal councils has been effectively playing the role of alternative dispute resolution system. The alternative dispute resolution system aims to avoid expensive and protracted litigations and arbitrations, and it is cost effective and ensure speedy and equitable justice to all stakeholders at the end. When the parties agree on the decision of a neutral independent party, it ensures improved interpersonal relations, a prerequisite for peace and order in the society. Since time immemorial, the tribal communities have been employing a sort of a dispute resolution mechanism, what we call modern legal jurisprudence as alternative dispute resolutions. In a tribal society, dispute arises, the arbitrator's primary concern is to ensure order in the society blazed by invoking community sanctity and sentiments. They resolve the disputes impartially, conforming to the traditional laws based on social practice and cultural ethos of the community. The arbitrators are neither selected nor elected. They evolve naturally, that they have social as well as supernatural sanctions. Arbitration begins with the invocation of Almighty and narration of the history of the community to which the party belongs. The justice delivered is impartial and instant. Normally, trial of cases does extend beyond a day. The arbitrators, having social and supernatural sanctions, consider the act of arbitration as a duty towards the community. All arbitrator ensures restorative justice, restoring harmonies to victims, offenders and the community. An offender is punished not for wrongful actions against the victim, but for bringing disorder in the society. Since the restoration of order in the society is the prime responsibility of any arbitration, each of the arbitration is marked by a community feast or erection of a community sign or pillar, usually stone pillar, equivalent to modern day covenant. It reminds only and oneness and signals the cessation of animosities and hostilities. May I draw the attention of my Lord Justice Kaul to paragraph 11 of my speech. In Arunachal Pradesh, an effective area in the form of village council is already in place. I feel that if the principle of the tribal laws of the various tribes, more particularly in respect of the personal laws like that of marriage, divorce and inheritance can be codified, it would go a long way to settle such disputes involving the personal laws through the village council, which would be more effective and a first remedy. Whenever such questions involving personal laws are also involved in the general proceedings in the municipal courts, Such question can also be referred to the village councils for a decision, and such decision can be made a part of the material for determining the question that may be involved in the general proceedings in the principal courts. For example, if the general proceeding is regarding entitlement of family pension, which also involves the questions whether there was a divorce between the deceased and his other wife by following the tribal principle of law, I feel that the village council will be a better situation to decide the said question, and its decision can be placed before the principal court as a material on the question of the existence of the divorce, and the principal court can determine the eligibility of family pensions accordingly, instead of itself attempting to determine the question whether the divorce existed. In such manner, there would be an effective connections and correlation between the ADR and the local tribal mode of dispute adjudication method. I am sure in the deliberation of this lecture series, during course of the day, all aspects of the team to explore the connection between alternative dispute redressal and local tribal modes of dispute adjudication will be discussed. I understand that a good number of participants from all walks of life have assembled here and will deliver different aspects of the team. I welcome to a fruitful discussion on this lecture series, waiting for an equally fruitful and valuable address from my bosom friend Kiren Rijiju, Honorable Union Minister, Honorable Mr. Justice S. Kaul, Judge, Honorable Supreme Court of India, Honorable Mr. Justice Nani Tagia, the Judge, Honorable Guwahati High Court, and others. With these words, I would like to thank Tewari and Associates for providing me an opportunity to put forward my views on the subject, as well as in welcoming all the distinguished dignitaries in this functions. Thank you so much.
Please request Mr. Tara and the GS Secretary of the Bar President to honor esteem, get a small token of love from the Bar Association and from the
Oh, sorry. This is the main one.
CA Judge, Itanagar Bench of the Guwahati High Court, Honorable Justice Sushmita Thanga, Judge, Guwahati High Court, worthy President of the Bar Association, Learned Advocate General, State of Arunachal Pradesh, the Deputy Solicitor General of India, senior members of the Bar, members of the Executive Committee of the Bar Association, senior officers of the Government of Arunachal Pradesh, members of the Honorable Bar Association, Itanagar Bench, young students from the National Law University and other colleges, members of the press, ladies and gentlemen. It is my great privilege that Tewari and Associates have had the opportunity to collaborate with the Permanent Bench, Itanagar Bar Association, for this lecture, special lecture by Honorable Justice Sanjay Kishan Kaul, Judge Supreme Court of India. The Union Minister of Law and Justice, Kiren Rijiju, needs no introduction, especially here. He is the son of the state. He was born in 1971 from an illustrious father. His father was the first pro-tem speaker of the Arunachal Pradesh Assembly. He did his education, his graduation and his law degree from the Delhi University. He is a third-term member of Parliament. He was Minister for Youth Affairs, Sports and Minorities between May 2019 and July 2021, when the responsibility of running the Ministry of Law and Justice was given to him. As a citizen, I find him to be young, charismatic, and with a very fine understanding of the dynamic of the relationship between the judiciary and the other branches of government. Sir, we are deeply obliged to you for having taken time out of your busy schedule to preside over this function. Honorable Justice Sanjay Kishan Kaul was born on the 26th of December 1958. He comes from a family of stalwarts who have had distinguished careers in public service over the last many generations. His Lordship also did his education from Delhi, from the Modern School, New Delhi, from St. Stephen's College, New Delhi, and did his law from the University Law Campus in the year 1982. His Lordship joined the bar at the Delhi High Court, where he practiced till 2001, when he was elevated as an honorable judge. He served the Delhi High Court till 2013 and was the acting Chief Justice of that court. He was appointed as the Chief Justice of the Punjab and Haryana High Court, where I had the privilege of serving with him. 13 short months later, he was transferred as the Chief Justice of the Madras High Court. I may remind everybody that at that time, the situation in the Madras High Court was very volatile. And it was His Lordship's very decisive and calm leadership, as a result of which the Madras High Court has again turned the corner and has become one of the premier high courts of this country. His Lordship was appointed as a judge of the Supreme Court on the 16th of February 2017. To even give a brief summary of His Lordship's judicial career would take, I'm afraid, too much time. However, I may say that his lecture today on alternative dispute resolution vis-a-vis the modes of dispute resolution in not only in Arunachal Pradesh but in other tribal and customary societies promises to be most thought-provoking, and I'm sure all of us are going to be profited by the same. My Lord, I thank you for having taken time out of your very busy schedule to be with us. And with that, I end my talk. Thank you so much.
Resolution call to deliver the lecture today.
Honorable judges of the court, this is Tewari, with whom I presided over the bench in the Punjab and Haryana High Court, president and office bearers of the associations, the young law students who have come here, ladies and gentlemen. At the outset, I would like to thank the organizers for giving me this opportunity to deliver the inaugural lecture of this event. And it's a great opportunity to come to this part of the country, even for a short period. And I hope to spend better and longer time in an opportune moment. I must first applaud the Bar Association's initiative for this annual lecture series, with the goal of inspiring more lawyers and instilling them in the need to undertake legal aid for the betterment of the society. I was pleased to learn of the initiative, and it's commendable that lawyers have come together and innovate towards the cause of legal aid and access to justice. The role of importance of a pro bono work by lawyers in the cause of access to justice cannot be overstated. I do believe that in places like these, possibly, there is a larger commitment, minus the monetary aspect, to a society emerging away from disputes than sometimes bigger metropolitans where the financial aspects overpowers it. The undisputed concept of access to justice, that it constitutes the primary tenet based on which our constitutional and legal framework operates. Every other principle of democracy that we hold dear, be it the right of equality, to our individual freedoms, to the effective representation, is underpinned by our ability to approach the law and appropriate machinery created for the purpose. Every assertion of rights begins with the possibility of an individual making themselves visible to the organs of the law. I would assert that every process of making an individual visible in the eyes of law to grant that person a certain permanence is facilitated by a lawyer, who is the person who is responsible for providing that ability to get access to justice. To no one will be sold, to no one will be refused or delay right to justice. These words from the Magna Carta not only have a great significance in the field of law, in different capacities, but have also led to pursuit of justice for several centuries thereafter. The all-encompassing principle embodied here forms the impetus for the creation of individuals' rights and means to protect them, all in the name of justice. In the Indian context, it would not be a stretch to say that access to justice forms the very core of our collective constitutional conscience. Article 14 of the Constitution of India carries under its wide umbrage the concept of access to justice as a corollary of equality before the law. This guarantee of equality will become obliterated if, in accessing justice, one has to encounter barriers of any kind. In a scenario like that, it would be safe to say that the existence of a functioning democracy with an independent and robust judiciary will come to a screeching halt. The Supreme Court, as early as in 1956, while interpreting the broad contours of Article 14, stated that our constitution is not means only for the elite, but it is also for the butcher, the baker, and the candlestick maker. From there on, the Supreme Court kept expanding the avenues by incorporating access of justice under Article 21. Further, Article 22, 1 and 2 specifically ensured the access to justice for those in conflict with law. In terms of enforcement of Part 3 rights, the right to move Supreme Court is guaranteed under Article 32. This right of Supreme Court is plenary, and the apex court, while exercising power under this article, in the words of then Chief Justice P.P. Gajendra Gadkar, had to play the role of a sentinel on the quay for protecting the fundamental rights of citizens. Access to justice may today have become a weather-beaten phrase, but if we are to retain and uphold our constitutional scheme, it is important that we delve deeper, debate and discuss the means and how we can actually effective it for our country. In this context, it is here that the role of the legal fraternity and the lawyers become inevitable. A lawyer is an extension of the court. It is a lawyer who enlightens the people about their rights, guides them in terms of the legal recourse available, and represents their grievances in court of law with due regard to the relevant statutes and the judicial precedent. In his role, a lawyer bridges the gap between the people and justice which they seek to achieve. I would say that with the growing litigation pending, one of the aspects which must be flagged for the positive aspect is that the access of justice is improved, and that is why people access justice. So we should not look at the growing litigation as only a reflection of disputes, but an assertion of right by people who would not be aware of the rights. And women's rights and empowerment is a very important aspect in this field. With the laws changing, the implementation of the gender-neutral law arises from assertion of the rights which people were not aware of or were unwilling to assert in the earlier scenario. As members of the legal fraternity, lawyers are the first individuals to be exposed in public grievances. The nature of legal profession in India is much wider due to the diverse range of problems across different states and general lack of awareness about individual rights and legal recourse available. The legal profession is not about self or individual service, but it is a mode of public service catering to the needs of the people. Lawyers must play a transformative role by meaningfully engaging with the society at large. In the same spirit, our former President, Shri Ramnath Kovind, had once stated, and I quote, "Law is not a career, it is a calling. Much more than a means to earn a livelihood, it is a mechanism to assist the cause of justice, to help the poorest to earn a livelihood, and most unfortunate among us, and to build a society and a nation defined by adherence to rules, norms, and fairness. Advocates and judges are, in the ultimate analysis, seekers of truth." Article 39A of the Constitution of India envisions free legal aid to the poor and the underprivileged. In this regard, lawyers have taken lead to render pro bono services and lend legal services to those who cannot access justice due to economic and other hardships. The legal services authorities have contributed significantly to the dispensation of justice, especially for the poor, underprivileged, and the marginalized sections of our society. Hearing several legal aid matters on a daily, I find it important to state that pro bono matters today are in the dire need of being pursued with interest. Several of these matters raise important questions of law which inevitably require nuances and expertise. Having been associated with the legal fraternity for several decades, I would like to share some advice with members of the esteemed Bar Association. In several legal disputes, litigation often becomes a time-consuming process and ruptures the relationship between the two contesting parties. There is also a certain sense of skepticism and litigants have while approaching the courts due to the exorbitant costs associated with litigation. In the light of these apprehensions, I would encourage lawyers to advise their clients to opt for different mechanisms of alternate dispute resolution, such as mediation, negotiation, conciliation, and arbitration. There are several advantages to such an approach. The conciliatory nature of proceedings allows parties to be in complete control and ensure that each gets a say in the outcome. This allows for innovative solutions that rely on techniques specifically tailored to the dispute between the parties. In today's fragmented world, perhaps the most important advantage is that this allows the parties to preserve their commercial and personal relationship as they were prior to the dispute. Mediation is also a cheaper, quicker, and for most litigants, friendly and traditional litigation proceedings. In the above context, it may be relevant to state an observation by the noted journalist Dorothy Thompson. Peace is not the absence of conflict, but the presence of creative alternatives for responding to the conflict. The mediation training program itself begins with a basic example. And that signifies why I believe mediation is a better methodology of resolving a dispute than possibly litigation, other than scenarios where constitutional issues are allowed. It talks about how, in a court of law, an coins would be divided between two competing parties. It says the judge would just divide it half and half, cut it half and say, look, if you have 50% share, that's how it will be divided. The mediator will make an endeavor to find out what are you going to do with it. So it's a solution based on the person who has gone into litigation. So if a person is requiring the juice of for particular needs, and the another person is making a jam out of the rind, then he would do a separation with the juice going to one and the rind to the other, which a judge is not capable of doing because of the nature of role he performs, as it is affected by the rigors of the law. As judges, we realize and agree that certain kinds of disputes are more amenable to the mediation. In a dispute, mediation prompts the parties to come up with solutions, unlike in a litigation where the solution is imposed on them. I believe that commercial disputes and family disputes are particularly receptive to such an approach, and accordingly to mediation. Mediation ensures that parties go to the table and are ready to find the efficient solution which results in a much quicker resolution and drastically reduces costs. Time is generally of the essence in both kinds of disputes. In family disputes, the premium is placed on maintaining the relationship during and after the resolution of the conflict, which often becomes impossible once the parties have through tedious and adversarial court processes. The interesting factor about mediation is that it is not limited by the institutional contours of law. The concept of mediation is not foreign to India, and in fact has been an important part of our ethos for ages, as the President of the Bar himself said in his opening remarks. Prior even to British rule, the local disputes were resolved by informal panchayats, where elders of the community were appointed as mediators. In this role, the elders would attempt to resolve a dispute, keeping in mind the community's long-term interests of maintaining harmony and collective prosperity. In India, there are still localized and customary forms of mediation that are still in existence. Arunachal Pradesh is itself a testimony to the long-standing tradition of customary mediation and alternative dispute resolution. Arunachal Pradesh has several diverse dispute resolution mechanisms that operate in addition to the adversarial courts. The Kibang is one such indigenous tradition system which also looks after day-to-day affairs of the villages. Unlike courts, the Kibang is a non-adversarial justice delivery system having beliefs in amicable settlement of disputes outside the courts. Similarly, the Naishi tradition have the Naili, which plays a very important role in administration of justice. Naili involves a council of elderly people who are well versed in local traditions, customs and practices, and they arbitrate local disputes on this basis. It is highly simple, yet sophisticated system with its own rules of procedures and evidence, and the decision, also known as Pabe, is considered a final and binding. I believe that the local systems of dispute resolution represent a more holistic approach, as they are guided by customs and traditions of the participants themselves. As I was going through a record of a recent decision of the various Nailis in Arunachal Pradesh, I learned that the punishment imposed were often in the nature of small fines, and sometimes even sincere apologies would suffice. Such mechanisms thus emphasize the need to preserve the integrity of the society and the family, and to treat justice as a pathway for healing and restoration. The only caveat I would have here is that at times my reading of the situation is that the gender equality process should not suffer in the bargain. When our constitutional scheme provides for an equality process, these local methodologies of dispute resolution must take the overarching constitutional process and ethos into consideration, and maybe modernize their system of local resolution colored by the larger constitutional processes. In a similar vein, it is my personal belief that mediation is a critical tool in our arsenal to combat the existing apprehensions of the people in approaching traditional courts. While in litigation there is one winner and one loser, mediation allows one to get to the bottom of the dispute, resolve its genus, and brings about a holistic change in the mind among the warring groups. In this context, I believe that it is critical to the advocate for mechanism of alternate dispute resolution and identify cases that could be settled through mediation. An effective lawyer is not only one that is able to apply the correct principles of law to a dispute before them, also someone who is capable of understanding the nature of the dispute and recommending its resolution in a manner most advantageous to the parties involved. This encompasses solving the dispute being litigated in court itself, or encouraging clients to take some dispute in mediation, conciliation, arbitration. Depending on the question raised, the competing interest of the parties, and the nature of their relationship. Every dispute is different, and not all disputes need to be resolved through an adversarial process. In India as well, the mediation is now seen as an enabling resolution to the workload of the judiciary, a better method of resolution, and a dispute resolution mechanism in its own right. Efforts on several fronts, not only for institutionalizing mediation, but also for inculcating a culture of mediation and an academic body study of discipline are underway. India is spearheading the scope of mediation in every way possible. It is also interesting to note that India became a signatory to the Singapore Convention of Mediation in 2019. And last year, the Mediation Bill 2021 was introduced in Parliament, which aimed at institutionalizing mediation and establishing a Mediation Council of India. The Law Minister is here, and I'm sure we will soon see the end result of this endeavor to bring the Mediation Act into force. It is my hope that all lawyers will utilize their positions to benefit society, and those in need defend their clients' interests, and most importantly, uphold the Constitution of India, as the actions of lawyers in the present will continue to impact the society in the future. I wish to express my appreciation for the sustained efforts made by the Bar Association, as well as the initiative taken by them in generating greater awareness, interest and understanding of legal aid, and the need for promoting other forms of dispute resolution amongst the seasoned advocates as well as the budding lawyers. I hope that this inaugural session is just the beginning of a long-term commitment to that issue. Thank you and Jai Hind.
Next stage is Nani Talia. That's Nani Talia.
Honorable Union Minister for Law and Justice, Sri Kiren Rijiju, my Lord, Honorable Justice S.K. Kaul, Judge Supreme Court of India, and Madam Kaul, organizers of this event, Tewari and Associates, as well as the Guwahati High Court Bar Association. I thought I will speak before Honorable Justice Kaul, and I have already been indicated we are hard pressed time. As far as the local dispute resolution in Arunachal is concerned, the state of Arunachal is inhabited by various tribes. On record, we read that we are 26 major tribes and more than 100 sub-tribes. Each of the tribe has had its own dispute resolution forum since time immemorial. But in the state of Arunachal Pradesh, this dispute resolution forum was formalized in the year 1945 when Assam Frontier Administration of Justice Regulation was introduced by the British in exercise of power of the Government of India in 1935, whereby the administration of justice was formally handed over to the executive. And along with the executive, an authority called village authority was introduced. Since then, the administration of justice was administered by the executive as well as the village authority, which continued even after the constitution came into force, in the days of NEPA, in the days of Union Territory, as well as after we had attained the statehood in the year 86 or 87. For the first time, steps for separation of the judiciary was taken by the government and initiated its phase-wise separation in the year 2010 and 11, where the subordinate judiciary was separated from the executive. And today, the judiciary is completely separated from the executive in the administration of justice. Now, in the year 2021, a year back only, we have enacted a Civil Courts Act, whereby, like all other states in the country, civil judge, junior division, senior division, and the district judges have been established. In addition to that, a very unique feature has also been incorporated, which we might not find elsewhere in the country. That is called customary courts. Customary courts have been defined as a traditional council or an authority of the village indigenous to the state by whatever name it is called, and it also includes the village authority defined under Assam Frontier Administration of Justice Regulation. Now, once this legislation is enacted, these customary courts will enter into adjudication of the disputes. Now, the composition of this village council has not been defined in the Act. And the village authority, which has a reference to the 1945 regulation, is only finds mention that it shall be appointed by the deputy commissioner. Now these two forums, the village authority and the village council, or the village authority, whatever name, when they will be administering the justice in resolving the private disputes. First area where it has not been clear under the Act is that what would be the composition of this village council or the village authority, and what are the eligibility criteria for appointment to these village authorities or village council have not been provided in the Act. Now, once they enter into adjudication, secondly, what has not been specified is what law this body will implement. Now, once any eligibility criteria has been prescribed, now whoever manages this body may not be a trained legal person. So under the circumstances, it cannot be expected that the law enacted by the legislature are administered by this body. Now, second area is that under the Act, an appeal has been provided against the decision of this village council as well as the village authority before the civil courts. Now, the civil courts are made by trained judicial officers having a legal background. Now, once the appeal against the decision of the village authority or the village council is filed before the civil courts, now the appeal will be judged by applying which yardstick? The positive law enacted by the legislature or the customary law that may have been applied by these bodies. And these judicial officers are neither trained in the customary laws. These are the shortcomings where the Act of 2021 does not make it very clear and the definition of the customary codes as well as the applicability of the law are inadequate in my view. Since the certainty of the law and the definiteness of the judicial or dispute resolution forum where one is to approach is an essential facet of the rule of law, and the legislation is only a year old. In my view, the people of Arunachal Pradesh would be served better if these acts are revisited at the level of the legislation. Otherwise, it may end up in a various, the court may have to end up with a various interpretation level. This I am highlighting since the law minister is present today, who apart from taking keen interest of the nation in the also takes a keen interest in the affairs of our own state. Quickly, I am also taking the advantage of the presence of the law minister. I would like to, digressing a little bit, which I have come across during presiding the court on the criminal side, criminal cases. The forensic lab, which is established at the PTC, Police Training Center in Bandradwar, I think that forensic lab lacks adequate infrastructure and lacks manpower. Now, compared to the other states, the offense related to the IPC is much less, but of late there is a growing the drug menace. The NDPS cases are in a rapid increase, and what I have noticed is investigating agency is facing much of the trouble in concluding the investigation of the cases related to the NDPS cases, which the NDPS case being a tough law, it is essential that forensic lab is established with adequate manpower as well as infrastructure. With this, I thank you.
To give the presiding remark.
Honorable Justice Sanjay Kishan Kaul, the Judge, Supreme Court of India, Madam Shivani Kaulji, who has accompanied here, Honorable Justice Itanagar, Judge, Guwahati High Court, Honorable Justice Susmita Phukan Kaul, Additional Judge, Guwahati High Court, and the Advocate General in charge of Arunachal Pradesh, Kartak Ete, and the Deputy Solicitor General for the Government of India, Marto Kato, and Advocate T.T. Tara, the President of the Itanagar Bench Bar Association, Advocate Uttam Bori, Secretary General, and Justice Ajay Tewari ji, the retired judge and senior advocate. All the learned advocates who are here on this very humble beginning, and invited guests and the media friends. First of all, I am extremely delighted that I am part of this first lecture series which you have initiated, and also to be with Justice Sanjay Kishan Kaul, one of the known as well as the senior most judge of the Supreme Court of India. Because of the time constraint, I reserve some of my remarks for the next occasion. Today, because I have to drop back Justice Sanjay Kishan Kaul to Guwahati, and there is a flying limit. And when it comes to aviation, we have no authority to deviate from the scheduled permission. So there is a time-bound flight route also And to pass page 2, we have to fly before around 3:20. So we have to take off by latest 3:35 or 3:40. So I practically is not left with any time. But anyway, I can anytime come back because this is my home state, so there's no crisis for me. I just want to mention a few quick things. There are lots of issues in the state which I will address later. But when we are talking about the tribal customary laws, we are talking about the alternative dispute resolution mechanism. We have to see the flow, how we are moving, and from our ancient practice to the modern common law, how is the journey, how we adapt ourselves to the changing need and time. We also need to establish something in the mind of the people that this process is natural. At times we say whatever court decides we will follow, but at the same time some people say no, we are from this particular community, we will go by the community decision. Now we are in the middle of this evolution. Still today in the Itanagar, in the capital also, people deliberately would prefer to settle the things by traditional methods. People will still say that we will go in by customary laws. People will still say that I don't need advocate, will not go to the law. Despite so much of advocates here, they will still say that I don't need advocate. Now, having said that, we also have a pendency in the bench, Itanagar bench of the Guwahati High Court. I was just informed that the pendency is around 1500 roundabout cases. So when we are talking about the pendency of the cases, we have much less than other parts of the country. Sanjay Kishan Kaulji is very excited that at least we have less pendency of cases in Arunachal Pradesh. So as a judge, he definitely would be happy. Now you can look at from other angle also, that why cases are not coming up to the court. It is difficult to believe that in today's modern time, in Arunachal, Guwahati High Court bench, Itanagar bench, only 1500 pendency. On the other side, you can see that we still large numbers of cases going to the traditional methodology. So we are bringing the mediation bill. Mediation bill has been tabled in the parliament. We are getting lots of feedbacks from the parliamentary standing committee also. I have clubbed it into 3 categories. One, which the government can agree with the standing committee recommendation. 2, which we will not agree with the standing committee recommendation. And 3rd category, we can accommodate or dilute or modify and partially agree to whatever they have recommended. So it's a series of recommendations which I have received. Most probably I will be able to clear in the winter session of the parliament. Now, when we institutionalize the mechanism, things will be much more easier. Right now, it is very much unorganized. It's a very ad hoc kind of practice we have in Arunachal Pradesh. Within the community also, things are interpreted in a different way from one village to another village also. It's not only the community, but from village to village also, the issues are settled by the mediator in a way he interprets it. There are well-established norms, there are things which are left to the mediator. The mediator concept, everybody knows, we will all have to agree to a particular mediator. And mediator also gives you the way forward, that things can be settled in this manner or that manner. So, once we codify to some extent, or once we make an institution, then from amongst the young lawyers we can have young mediators. I want mediators to be trained. When I visit the law universities, I tell them, we want good arbitrators from now. We want good mediators from now. Now, good law students will become good mediators. Good law students will become good lawyers. Good lawyers will become good judges. So it is all linked. So we have to formalize entire process. Arunachal is a unique place, and I very well understand. I require to reflect my thought about it, but as I said, next time when we meet again, we will definitely reflect on some of the issues which I also have certain thoughts on it. But for today, I think this much is enough. One thing I want to also ask the lawyers and the judiciary also, that we need to do a little bit of more for the legal aids and awareness program in Arunachal Pradesh. And NALSA program, which is guided by our senior judge, NALSA program needs to be activated more. And also, we need to implement some of the government schemes much deeper, the tele laws, the Nyay Bandhu scheme. All these are not up to the mark in Arunachal Pradesh, which I definitely would like to take review meeting. Last week, 2 weeks back, we had a law ministers conference. Arunachal was represented by the minister and the secretary law. So secretary law also informed me that there is a arbitration center in Itanagar which is actually not functioning. We need to put that into functional mode. And also, he made me certain issues to ponder about, which also I feel that I need to discuss with him. Another thing is, there is no much coordination between the Lord Judiciary and our administration, especially in terms of the infrastructure planning. So infrastructure planning is another issue. I met our district judges, our district judges are here last time. They came to Delhi for the district judges conference. So they met me. So there is a gap, because what I feel is other states, the law secretary is the district judge. One of the district judges happens to be law secretary. But in Arunachal, the law secretary is not a judge. So probably there is a gap because of that also. And last March, not this March, last March, I could not spend money for Arunachal Pradesh. It is disgraceful for me that I have so much of money with me, but I am unable to spend it simply because the rules are not followed or it's not implemented as per guidelines. And I want to do more when I get representation from the district courts. Our district court buildings are in shambles, no proper toilet building, no proper lawyer's hall. We don't have a smart room fitted with digital, all gadgets and all. So we have money, it's not that we don't have money. We have enough budget, especially for the lower judiciary. We can fund, but the only thing is, the money is not being utilized. The proposals are not coming as per the rules or guidelines. So these are small things which we need to tackle it. I want the law secretary and some of the officials from Arunachal judiciary to sit with my office team, sit with my secretary justice, sit with my other officers and sort out and try to get more fund for Arunachal Pradesh. The entire northeastern states require lots of help from central government because we don't have our own internal budget in the state enough to fund those critical gaps, which I will definitely give priority to. So on the issues, I have many things, but as I said, due to the paucity of time, I will conclude. But next time, in this kind of good initiative, we certainly will have occasion to discuss about many other issues. And I'm going to Kaziranga only. We have a judicial conference. I think 8 or 9 Supreme Court judges are also coming. So many High Court Chief Justices are coming to Kaziranga. So I'll be there, but Justice Sanjay Kishore Kaul will be heading back to Delhi. And I'll attend that event and then I'll talk to the bar people here and look out for one occasion where I can share my thoughts with much greater space and much more free time. Thank you very much.
And hearty thanks to our Honorable Justice S.K. Kaul, Judge, Supreme Court of India, for coming to the state of Arunachal Pradesh and giving this bar an opportunity to learn from you. It's been an honor and privilege to watch you at this young bar. I would also like to express my gratitude to Honorable Union Minister for Law and Justice, Mr. Kiren, to bless us with his kind words, and we thank you for being with us. I'm also thankful to Honorable Justice Mr. Itanagar, Judge Guwahati High Court Itanagar Permanent Bench, for your kind words and guidance. At this juncture, I would also like to thank Honorable Justice Susmita Guwahati High Court Itanagar Permanent Bench for her gracious guidance. Now we conclude the session, and I would like all the attendees to join us for a high tea in the next hall. Thank
Okay, right. मैं तो वहाँ जयपुर तो जाएगा हाँ okay